It's December 27th, 2025, and the cat is running the show. Welcome to the Court Gallery. Ladies and gentlemen, welcome to the Court Gallery. I am your lone wolf Usul, and we have a big show set up for you today. We got about 2.5 hours worth of court shenanigans. We're starting things off with Judge Middleton. He had quite a few issues to deal with on the 23rd. We're going to move on, sticking with the 23rd, going to Judge DiSanto. I cannot even describe all the things that happened with Judge DiSanto because I don't remember any of them right now. But I put all this together, and I assure you, it is very, very interesting. Lakewood, Washington, same situation as DiSanto. I have no clue what happened there. I didn't read my notes. I have no clue. But it's an interesting show, I do assure you. And all I have to say to support that is we're rounding things off with Thurston County from yesterday. Ladies and gentlemen, this is the Court Gallery. I have no clue what's in store. It's going to be an interesting show. Actually, that's not true. I have some pretty good ideas what's going. If you're interested in what's happening in today's show, take a look in the description. Time codes are there. All of the case descriptions. Ladies and gentlemen, it all gets started right now.
Good morning, we're live. We're going to start our arraignments here in a few moments. Today is the 23rd of December, the eve of Christmas Eve. It's our last working day before Christmas. Yesterday I want to thank everybody that sent me cards. I have a bunch that I've gotten and I appreciate them. Got some yesterday from TJ, Sarah, and Tegan. I think they've been here to visit. Paul from Normal, Illinois. Very nice card. Miranda from Chicopee, Massachusetts. Thank you for your kind comments. Allison and Jimmy, our friends from Alpena. They've been here several times. Hope you got some snow up there. Thank you for thinking about me. And a nice card from Beth from Bidwell, Ohio. Very nice comments. Thank you. Plus the others I received earlier. Paul, Emily, Robert, some others. I hope our friends in the Caribbean are doing all right. Jill, I hope you're okay. And Romulus, Javier, I hope you're good in San Antonio. And I hope everybody is doing all right, including the people that watch every day from around here. I got Christmas cards and I appreciate that. Here's today's Christmas card. The first line, you either know this song or you don't. Either way, it should make you smile. If you know it, you'll know it right away. If you don't know it, then listen to it. And that's my Christmas card. It's been covered a number of times, but the original song is by Robert Earl Keen, who's another guy ought to be a lot more famous than he is. If you live in Texas, you know who he is. Anyway, this is a lot of people's favorite Christmas card. I went to Weeki once, long time ago. All right, here's my Christmas card. Listen to this and smile. If you know it, you'll know it right away. You only got to get a line or two. Mom got drunk and Dad got drunk at our Christmas party. We were drinking champagne punch and homemade eggnog. And it goes on from there. It's been covered, as I said, a number of times, but the original is the best. David, you got it? Everybody else, maybe listen to that. That's my Christmas card. We have arraignments. We have pre-exam conferences and a complicated set of pleas we're going to attempt to take today. So we're going to be busy this morning. We don't have anything set for this afternoon. I'm not sure how that happened, but that's probably good. It's not a cover. Robert Earl Keen's is the original. It was covered by a number of people. Jill Sobule, Mavericks. Terrible cover by the Dixie Chicks with Rosie O'Donnell ruining the song. Anyway, I hope you like it. Morning, Mr. Smith.
Good morning,
Paul,
Yeah.
Mr. Kettlehut is here. We can go ahead and make a record on that
Okay, yeah.
case. All right, we're still on the record. In fact, I think I'll stop it and restart it rather than have a 2-hour long record. We are still on the live feed. This is People versus Ernest Kettlehut. File number is 252522FY. Mr. Kettlehut is here with his lawyer, Mr. Paul Gibson, charged with harboring a felon. That's a charge we see occasionally, maybe a couple of times a year. It is a felony. It's punishable by up to 4 years in prison, and the defendant is charged as a habitual offender, which makes it punishable by up to 6 years imprisonment. The complaint alleges that on or about December 9th of 2025, he did harbor another person who is subject to arrest to shield them from police. And it doesn't say who the other person is. Well, if you dive further into the case, the other person is Christy Keen, Keen. Mr. Gibson has been appointed to represent Ms. Keen on the underlying felony. And he can't represent both Christy Keen and Ernest Kettlehut in this same matter. And the clerks, I don't think, realized it when they did the appointment. So, Mr. Kettlehut, we're going to have to get you a different attorney and adjourn your case.
Can I ask a question?
Yes, sir.
I thought it was only a conflict of interest if the attorney was, like, say, co-defendants and they were telling a different story.
Potentially, you can hire an attorney. Two people can hire the same lawyer.
But it can't be appointed.
Can't be appointed.
Okay.
So, just for all concerned, I want to make sure that we don't run into problems down the way. All right. Record made. Attorney conflict. Gibson also represents Christy Keen, who isn't here. She's about to get a warrant for her arrest. So appoint new attorney for Mr. Kettlehut. I don't want to cram this into next week. It's a short week, so I'm going to set the pre-exam for January 6th at 8:30. We'll set it out 2 weeks. I should keep it on my week. And if a prelim is needed, it'll be January 13th, 2026 at 1. Mr. Kettlehut, are you still on Riverside Drive?
No, I'm staying with my father on 704 7th Street.
All right. So we're going to get a new lawyer for you. Mr. Gibson's still going to represent Ms. Keene, although she's apparently not here. We'll deal with that in a minute. But for your purposes, I appreciate your patience. You're free to go. We're going to get a new lawyer. I want you to call your lawyer, make an appointment to discuss it with him prior to January the 6th.
Okay, who will be my new lawyer?
I don't know yet. They're going to take you out and there's a roster and they'll address it. Mr. Smith, what are we doing on your case?
Your Honor, I represent Mr. Jesse Carter.
Mr. Carter, would you come up and have a seat, please? This is file number 252423FY. You're charged with carrying a concealed weapon, other weapons violations, and most importantly, a moving violation causing death. Those are all felony charges. Well, actually, the moving violation is a misdemeanor. As far as I'm concerned, it's the most serious of the charges. But let's talk about this case. It's alleged that on October 5th in Constantine Township, you did have a double-edged knife in your truck and a possession of metallic knuckles. People don't realize possessing those is a felony in Michigan. Those are each punishable by up to 5 years imprisonment. The charge of moving violation causing death used to be known as negligent homicide. Several years ago, the state legislature changed it to a charge called moving violation causing death, which is a misdemeanor punishable by up to a year in jail and a fine of up to $2,000. With that, Mr. Smith, what's our current status here?
Your Honor, the matter is set for exam a week from today in the afternoon. I wanted to research, perhaps the court knows right off the top of your head, the alleged, so this was in there, apparently there's an inventory search after the accident that occurred. One of the things that was found in my client's work truck was a Milwaukee duct tool that had a sharp edge on one side and like a serrated edge on the other side, and whether that meets the definition, being that it's a Milwaukee tool, of a dangerous weapon. The idea that any type of people who do duct work need to have a concealed pistol license in order to transport that around seems a little bit far-fetched, but that's...
All right, so there's an issue regarding the definition of the knife.
Correct.
All right. And then the metallic knuckles are not an issue, but obviously the more serious of these in terms of consequence. Now, I need to make a disclosure here. I discussed this with Judge Pattison. The deceased here, Kenny Ray Griffin, I knew him, watched him when he was a kid. His mother's here, and I know his mother. I go into a restaurant quite often, including last Saturday. After Kenny Ray died, they posted that they were taking donations on behalf of the family. I stopped in at the restaurant and made a donation to Kenny Ray's fund and gave his mother a hug and told her I was very sorry. So I need to disclose that I do know the deceased. I know his mother, and I made a contribution to help pay for his funeral. So Judge Pattison thought perhaps maybe I should put this on his docket. Mr. O'Bear, do you have any objection to that?
No.
Mr. Smith?
I have no objection.
All right. I don't want to have a conflict or have an allegation of a conflict. If this does result in a felony, the matter would go to circuit court and Judge Stutzman would deal with it. If it is a plea to the moving violation causing death, it would be a district court case done by me. Every year for the past 16 or 18 years, every other year, every election cycle, a judge from Farmington Hills and I teach sentencing to new district judges. And the most difficult sentencing a district judge has is this charge. It's not breaking an illegal entry or assault and battery or domestic violence, drunk driving. It's this. It's moving violation causing death. We have many of these. My partner has never had one. We have 10 or so a year. And each one is very difficult. So I'm going to continue this to a pre-exam conference for January 13th. That will put the matter on Judge Pattison's docket. And if a prelim is needed, no, January 6th. Let me get this right. Yeah, January 6th. Does that work for you, Mr. Smith?
In the morning?
Yes.
Yeah, just January 6th in the morning works.
And a prelim would be January 13th. If needed. At 1 o'clock. All right. That may be a legitimate issue. I don't know what the definition of a dangerous weapon is. Whether it's a tool. Sometimes it comes up as an issue with as a box cutter with a retractable blade. People often carry those in the course of their employment. I'm not sure exactly what this is. Metallic knuckles either are brass knuckles or not.
Your Honor, with regard to the exam date, I'm already triple booked that afternoon.
Well,
I can just address that.
at the pre-exam, you can establish which date the prelim is needed for, if it is needed. But this moves this to Judge Pattison's docket. And he doesn't know the parties, didn't watch the young man grow up, and won't have any potential issues. All right, Mr. Carter, you still live in Mattawan?
Yes, sir.
All right. Stay in contact with your lawyer, and next court date is January 6th at 8:30. All right, you're good to go.
Thank you, Your Honor. Oh, there was, this is the only time I've ever seen it, that my client's employer filed a motion in this court.
Oh, yes.
Yeah.
That's hanging out here. They did. And let me see where that is. It's somewhere, but it isn't here. It's in my office. Have you seen it, Mr. O'Bear?
He told me about it. I haven't looked at it.
Well, let me see where it got filed. the truck is still an impound or investigation or something, and the owner of the truck wants the truck to be released. I thought it was in this case.
It is.
And it is, but it isn't in the case. And I'm not sure that they did it correctly. Well, let me take a short recess. I'll go out and find that paperwork and we'll come back and address that issue.
You're right. I do have another conflict. Essentially, it's my understanding that the prosecutor, unbeknownst to Mr. Robert and Ms. Davis, had indicated that if we wanted it released, that that was the only reason it was being held. And we've contacted her about that. So I'm guessing that we can just resolve this with her.
All right.
You don't need to make a ruling.
All right. I'll indicate that Attorney Smith is working with Prosecutor Davis for release of the truck. All right, I'll just leave it at that for now. All right, thank you.
Thank you.
All right. January 6th. That will be another pre-exam conference like this, where they will discuss what's going to happen. The two weapons charges, the serrated knife and the brass knuckles, are felonies, which require that the matter be transferred to circuit court. If it goes to circuit court, it'll be set for a status conference, which would be several months from now. If it stays in district court as a misdemeanor, if it's resolved as a plea, it would be done fairly quickly. If it's set for a misdemeanor trial, it would be done also fairly quickly, probably March. So I don't yet know where the case is going, but it's going to be in the hands of Judge Pattison when you're next here on January 6th. All right, thank you. Good morning, sir. Are you Chaz D'Artagnan Webb?
Yes, sir.
This is Judge Middleton. I know you, but I had to identify you for the record. Your lawyer, Mr. Paul Gibson, is here with me, as well as Chief Assistant Prosecuting Attorney Joshua Robert. You got yourself charged with resisting and obstructing a police officer. It's alleged that on December 5th, that you did resist or obstruct a police officer. That's a felony. It's punishable by up to 2 years imprisonment. You're also charged as a fourth habitual offender, making it theoretically punishable by, I think, up to 5 years imprisonment, maybe up to 15. At any rate, the prosecutor is dismissing the felony charge for a plea to a misdemeanor charge of attempting to resist or obstruct a police officer. Mr. Webb, attempting to resist or obstruct a police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Mr. Robert, you confirm the plea agreement?
Yes.
Mr. Gibson?
Yes.
Mr. Webb, are you going to plead to attempting to resist or obstruct a police officer as a misdemeanor?
Yes, sir.
Anybody threaten you to get you to do that?
No, sir.
Or promise you anything?
No, sir.
Do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have a right to be represented by an attorney. Mr. Gibson has been appointed to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. You'd have a right to have any of the witnesses for or against you subpoenaed to come to court. And you'd have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right. Now, according to the bond information report, you were with this other guy, Mr. DeWitt. You guys got pulled over at 8 o'clock at night on December 5th. And they learned that Mr. DeWitt had a valid warrant and you had a valid warrant on an assault and battery charge. You were in the back seat of this little Saturn Ion and you didn't want to get out. Did you not cooperate with the police by trying to get you out of the car and into the police car?
I had gotten out and whatnot. I just was on the phone with my girlfriend, and when he told me to put my hands behind my back, I was just like on the phone trying to talk to my girlfriend or whatever, and I didn't really comply with what he wanted to. And
Well, they wanted you to get off the phone and
Yeah,
then you
it-
just sort of
it
test
all-
your body up.
It just happened too fast. That's all it was. I wasn't trying to resist or not do what he wanted me to do. It all happened fast.
All right, but they had to then take you to the ground and cuff you and to get you in the other car.
No, I was trying to give him my arm, but my face was in the snow and his legs were in the center of my back. So I was trying to put my arms behind my back, and he was like not really making it very easy. Like, I
Did you
was even
say to
telling
the
him-
police, I'm stronger than you are?
No, I told him because he kept trying to like whip me around the other way, and all I told him was that he wasn't gonna manhandle me. I didn't tell him that he was stronger than I was.
All right, well, I first met you when you got a tobacco violation, which was about as minor of a misdemeanor as there is. In fact, I'm not even sure it carries a jail sentence. You were about 17 or 18. And I've watched you continue to make bad decisions one after another. You've been in jail now, I think I counted 18 days. You've got another case pending, an assault and battery case. If I sentence you on this, are you gonna be able to post bond on that assault and battery?
I doubt it, to be honest. I
All right, well, I'll
posted bond one side, but I can't get a hold of my family right now. Probably being because it's so close to Christmas and whatnot, my family's probably been buying presents and traveling and, so they're probably spent for money as far as right now because it's so close to Christmas.
All right, well, I'm gonna have to keep an eye on it because you're entitled to a PR bond after 28 days.
Mr. Gibson asked about that case. I responded to his email and offered if the defendant wants to plead to disturbing the peace in that file, we could resolve both cases today.
All right. Laura, would you bring me the Chaz Webb misdemeanor file?
And can I talk real quick? Okay.
What?
I was asking if I could speak to you real quick.
Yeah. I'm here. Just a minute. Let me. Go ahead.
I just wanted it to be noted that this is just a little hang up for me, like that I didn't want any of this to happen, but if I was to be able to get out, the sooner the better, really, because I was honestly on my way to rehab. Like I planned on going up to Bear River just to get away from Sturgis and to get my life rolling. Cause I just now found out about that place and I have a friend that works up there. Her name's Jasmine Wellman.
All right. Well, let me get the other case. Laura, could you bring me fail to appear assault and battery 251474 SM? I let you out of jail as a Christmas present, where are you gonna go?
I'm going to my mom's house right off of Big Hill, or not Big Hill, right off of US 12.
On Sunnyfield?
Oh, no, 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 no. That's a bad idea. I would be going, it's right off 12, up there by the Hillcrest Bar.
All right. Do you have a
That would
way to
be-
get there?
Yeah, I probably would be calling DeWitt for a ride.
All right. I'm waiting for that other file. I'm not sure if they can hear me. Will somebody bring me Chaz Webb's A and B case 251474 SM? All right, we've established a factual basis for the attempted resisting obstructing. Had you been drinking?
Huh? No.
It didn't indicate alcohol. You and your buddy got pulled over. He had a warrant for his arrest and you had a warrant for your arrest. Correct?
Right. Yeah.
It is alleged that on June 30th, that you assaulted Rebecca Jo Simmons in the city of Sturgis. That's assault and battery. That's a misdemeanor. Here it comes.
My toner's out. Jen's computer.
It is punishable by up to 93 days in jail and a fine of up to $500. You got into it with this girl. Mr. Robert, the chief assistant prosecutor, has agreed to dismiss the assault and battery charge if you plead to disturbing the peace. Disturbing the peace is a misdemeanor, but it's not an assaultive crime. Has to do with whether was there a quarrel, argument, or disturbance in a public place. Punishable by up to 90 days in jail and a fine of up to $100. Are you willing to plead to that charge?
Yes, sir.
Do you understand that you're giving up the same rights that you have in the other case by pleading to disturbing the peace?
Yes, sir.
All right, this sounds like a bunch of middle school kids or maybe elementary school kids. Rebecca Simons reported an assault. She was walking down the street and two men rode by on bikes. The two men screamed snitch, to which Rebecca replied, faggot ass bitches. Rebecca stated the suspect's motive was because she gave information about a house which led for a search to be done. And you came back behind her and smacked her as you rode by on your bike. Do you acknowledge that?
Yeah.
All right. On the disturbing the peace charge, that means you don't have to have a pretrial in January. Let's got arrested on 8/26, posted bond on 8/27, and you did 18 days just now. So I'm gonna give you 20 days jail credit, 20 days, leaving 0 days to serve.
Yes.
I believe you did post a $100 bond. Fine is $125. You post that $100 of bond, you owe $25 by February 15th. On the attempted resist and obstructing, it wasn't much of an attempted resist and obstructing. You just stiffened up, didn't cooperate, got your face mushed in the snow, and you've been in jail for 18 days. You have $330 worth of unpaid fines and costs.
I should be
On
able
a
to.
previous assault from 2020 and an earlier attempted R&O. All right, I'm gonna give you the minimum fine, but you have to pay it before you get out.
How am I gonna do that?
You'll be all right. All right, I'm gonna order 18 days jail credit, 18 days, leaving 0 days to serve. I'm gonna waive the fine, I'm gonna waive the attorney fee of $125 or 2 additional days in jail. I'm not gonna give you time to pay that because you haven't paid your last set of fines for attempted R&O. Somebody will put up $125, you get out today. Otherwise, you'll get out Christmas Day.
Damn.
All right, Mr. Webb, 2026 is coming. How about if you don't come see me in 2026? That would be good for both of us. All right, sir, that takes care of both of your cases. I gave you 20 days credit, 20 days in the disturbing the peace, and a $25 fine, which is due in February the 15th. In the attempted R&O, the felony reduced to a misdemeanor. I gave you the minimum allowable fine, but I made it due before you get out of jail because you haven't paid your last fine for the same thing. So good luck. If you pay today, you get out. Otherwise, you get Christmas lunch at the jail.
Let's go on the record the matter of Charles Abdul Kareem versus Hussein Alabazi and all occupants, 2502133. And Mr. Abdul Kareem, your name for the record, please.
My name is Charles Kareem.
Okay, thank you.
Okay, yeah.
And Ms. Getter, your name for the record, please.
Okay, here.
Search for your vehicle on your device and select it once it is found.
Ms. Getter, please unmute and turn on your camera.
Hi. Oh, sorry. Okay. I was trying to figure out what happened.
Okay, you're not driving, are you?
No, I don't know how. Oh, I went too far. Okay.
Okay, so Ms. Getter, are you driving or no?
No, Your Honor, I'm not driving. I just have to stay in my car.
Very good. Okay. And so, ma'am, your name for the record, please. Your name for the record, Ms.
Oh.
Getter, please.
Ellie Getter.
Okay. And can you spell your first and last names for the record, please?
First name spelled Elli. Last name spelled Getter.
Okay, thank you. All right, so my notes show that you all were here on December 9th, and that Ms. Getter indicated she was requesting rental assistance and that she was going to submit that documentation within 5 days. I do see that that was submitted. December 12th. Okay, and so ma'am, what's the status of that?
Your Honor, all the help that I tried to get asked for a lease. I tried to contact Mr. Charles, and I could not get a response from him. I also tried to contact him about the pipes being frozen at the house, and
Just one moment, ma'am, we're doing one thing at a time. Mr.
Okay.
Abdul Kareem, did Ms. Getter try contacting you regarding a lease?
No, Your Honor.
Not at all. She didn't contact you at all.
I swear on
Did she contact you at all?
No.
Since you were last in court?
No, Your Honor, no. She cannot contact me for the simple fact is I blocked her number and I blocked her text message.
Why? Why would you do that, sir? She's still in your property. Why would you block her?
Well, we was here the last time, when she says you call me and then he used the word FF, whatever, she made a statement on record. I'm sure it's recorded. And then since then I blocked her because this lady here, I don't want to get involved with her, Your Honor. All I want her to do is get out of my property.
Pause, sir. Just one moment. You may want her to get out of your property. However, there's a legal way for it to happen. And if she's still in your property, then you need to unblock her so she can communicate with you. Because now this court's going to have to adjourn it one more time because she needs a lease for her rental assistance.
Can't give her. I refused to do the last day of my property, give her these
Excuse me.
months.
Sir,
Yes, Your Honor.
she needs a copy of the lease to submit to the rental assistance agency.
Your Honor, with all due respect, I don't need to cut you off. Her name is not on the lease. You already saw the record. You already have a copy of the lease on with the
Sir,
possession.
whether her name is on the lease or not, that is not for us to make a determination on because she needs to submit the lease to the rental assistance agency. If they determine they're not going to give her rental assistance because her name is not on the lease, that's up to them. You need to unblock her number so she can communicate with you regarding the rental assistance needs.
Honestly, I don't trust her. I don't trust her from here to over there. Because this lady here, she have a felony on her record. And this lady had that.
Sir, stop. We are not going any further with this hearing. The court adjourned it to today because this was the 14 days after she was submitting her. Stop interrupting me. Submitting her rental request. Her rental assistance request. That is why this court adjourned it for the 2 weeks. Ms. Getter, did you make rent payment for December?
I'm sorry. What was that, Your Honor? I was coughing.
Did you make a rental payment for the month of December?
Did I? No.
Why not?
Well, I haven't been able to communicate with him. I've been trying to get help.
Don't interrupt, sir.
The agencies won't help me if I don't have a lease.
Ma'am, whether or not you cannot submit the lease or not communicate with Mr. Abdul Kareem, you know how to make the rental payment, correct?
No, I don't. I haven't been paying the rent. It was my ex that was paying the rent.
Understand that. You don't have any way to get in touch with Mr. Abdul Kareem.
No, I don't. I don't
Okay.
talk to my ex. I have a PPO out on my ex.
Just, ma'am, I'm aware of all those details. So
Okay.
let me just ask you this question. You have the money to pay for rent, correct?
No, I don't have the money to pay for rent. I've
Don't have
been
any money
dealing,
for December.
no, Your Honor, I've been dealing with the frozen pipes. I've been trying to, I've been trying to get the pipes unfrozen.
Can I speak, Your Honor?
My ex turned the utilities off on me, and I was trying to pay those as well. I paid $300, 2 months, 6 weeks ago on the utilities. You know,
Can I speak, Your Honor?
Just one moment. No, I'm not having either one of you speak. Just one moment. Do you have a copy of the lease with you right now, sir?
Yes, Your Honor.
Very good. We're gonna make, is that your only copy or is that a copy?
That's the original.
Okay, great. We're going to make a copy of it. Ms. Getter, you're going to come to the court and you're going to pick up that copy of the lease.
okay, Your Honor.
Your Honor.
Not right now, sir. Just one moment. You have to be here by 10:30 to pick up the lease, ma'am.
This one. So do it already.
Ma'am, further, my notes show that Mr. Abdul Karim was willing to allow you to stay until January 1st if you paid December rent. So, you have to, the court's going to order an escrow order. Well, the court has to wait on that because you haven't been able to get information about rental assistance because you didn't have a copy of the lease. We will adjourn this to January 6th. That's 2 weeks from today.
Your Honor, can I speak before you close the case?
I'm sorry?
Can I speak, please?
About what, sir?
Your Honor, I'm paying $14,000 in property tax. Her ex owes me for September, October. October, November, and now this is $9,000. And now you already given her 14 days, Your Honor, with all due respect, to come up with some money for December, and shall not.
No, sir. No, stop. Sir, stop. I did not give her a 14-day adjournment to come up with the money. I gave her a 14-day adjournment that's required per the court rules because she said she was requesting rental assistance. That 14-day adjournment now has to get adjourned because you blocked her and then she could not communicate with you to get a copy of the lease. Do not interrupt me. Do not interrupt me.
Yes, Your Honor.
You did not allow her to have a copy of the lease. You blocked her. So stop interrupting me. So for whatever reason you blocked her, you blocked her. She could not provide a copy of the lease, which was necessary for her rental assistance request. Therefore, because you do not communicate with her, there's another 2-week adjournment so she can submit that information for a rental assistance request. This matter is adjourned to January 6th at 8:30 a.m. in person, ma'am. You need to be in person
You said January 6th.
at 8:30 in person. Yes. So whether
Okay, Your
her name
Honor.
is on the lease or not is for the rental assistance agency to determine if they're going to assist her or not. But they need the copy of the lease to whether they approve her or deny her for her rental assistance. Then I can proceed moving forward.
Yeah.
We'll see you back January 6th at 8:30 a.m. Did you provide the lease?
Yes, I give it to
Copy of the lease?
I give it to the officer on.
Bobby, did you make a copy of the lease?
Judge, I don't know anything about it. I've been doing.
You took it inside to make a copy, I think.
Okay, do you have the lease back, sir?
No,
Okay, so just have a seat and you're gonna copy the lease back in just a short bit.
Must be Brian.
It was Brian, yeah.
you say January 6th?
January 6th, 8:30 a.m. in person. Ma'am, you need to be in person. Sir, you need to unblock her number so she can communicate with you regarding what she's indicating there are broken pipes. I would presume that you'd want to know that information to preserve the value of your property.
Oh, yeah, once you show up, she has an outstanding warrant going on.
Sir, the extra comments are not necessary. Make sure you unblock her so she can communicate with you regarding the broken pipes and any other issues that may arise with the house.
Okay, I got it.
Okay?
Find you. Can I call police officer? To go?
I can't give you legal advice.
Because I don't trust her to be there. But-
I cannot give you legal advice. You can contact who you want to contact, sir.
Okay, I'll call the police. Thank you.
Have a good day. Okay,
Thank you, Your Honor.
have a good day. Let's go off the record. And then we are on the record in the matter of the City of Wyandotte versus Terry Plumley, 251753.
Good afternoon, Your Honor. Just the family agreement of like this time sent to Manning reviews.
Okay, Mr. Plumley, your name for the record, please.
Terry Sean Plumley.
Okay, and today is the date scheduled for the arraignment as your client's in custody. Counsel adds to the arraignment.
Moving forward.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pre-trial on January 7th. At 9 a.m. As to bond, counsel.
Your Honor, in this circumstance, my client is not on probation or parole. I looked through the nature of the case. He indicated that his name was Sean Plumley instead of Terry Sean Plumley. His middle name is Sean. I see that's why they charged for fraudulent schemes. Judge, in this circumstance, he does have gainful employment. He indicates that he will stay in the state of Michigan, although his address does reflect an out-of-state location. He indicates he has a place where he can reside. I'd ask for any leniency when determining an appropriate bond. I know financially a large amount would be a constraint. Thank you, Judge.
All right, sir. How long have you been up in Michigan?
I've been here for several months. Since I've been here over a year.
And you haven't changed your address?
No, I haven't. I just hadn't gotten around to it. I don't know why. I just hadn't gotten around to it. I apologize.
And who do you live with, sir, at the home in River Rouge?
I stay with a friend of mine, Heather Glidden. She lives at 62 West James Street in River Rouge. I was staying at a house of Marshall Trushan's, 99 Seacott. I did a lot of work for him. I do a lot of work for Marshall. I was working for Miss Holly. She's a River Rouge police officer. I work for various people. Whoever needs something done, I just they get
Okay,
all
sir,
over
if
me.
you were to test right now, what's in your system?
Probably methamphetamine.
And are you on probation or parole anywhere?
No.
Not in Tennessee either?
But yeah, I'm on probation in Nashville.
Okay, so I said anywhere and you told me no. So
I was
there's
thinking-
another
Here.
lack of truth. And
I was thinking
it's
here.
also alleged, sir, that
apologize.
you spelled, stop, please. It's also alleged, sir, that you spelled your middle name and you spelled it incorrectly as well. And
I
it
never
appears
spelled
as
it.
though, sir, you have a pending matter from April in River Rouge. What's going on with that matter?
I don't know. I don't know about nothing in River Rouge. What would that
Well,
be?
misdemeanor obstructing police, felony drugs, and misdemeanor obstructing.
That's not, I don't have anything in River Rouge like that, ma'am. I've not had any issues with any drugs or anything.
There's a warrant request on there, so I don't know if that warrant's come back or not. What
I
are you
don't know
on
what that's
probation
about.
for? What are you on probation for in Tennessee, sir?
Sexual exploitation, something like something like that about it was a attempted sexual exploitation. That's all that was. But I don't know about any
And do you have
drugs.
permission, sir? Did you have permission to leave the state of Tennessee?
Yes,
You did.
yes.
And so did you not show, is it alleged that you didn't show up for a hearing or an appointment?
Probably an appointment.
All right, well, given the nature of your charges and that it shows, it appears as though it shows deliberate attempt to mislead the officers and misspelling your name even.
I didn't write my name down.
Excuse me, sir.
I spelled it.
I didn't say you wrote it down. And I'm not going to have you go back and forth regarding the allegations right now. But mainly because your client has moved around since he's been up here in Michigan and has multiple connections to Nashville and is wanted out of Tennessee. The court's going to order a $5,000 10% bond
Okay,
with the following bond conditions. You're not to possess or consume any alcohol or drugs that are not prescribed, and you're not to be released without GPS tethered through the Wayne County Jail. We'll see you
Yes,
back on January 7th at 9 a.m. Thank you.
Thank you.
All right, let's go off the record. Okay, so let's go on the record in the matter of the state of Michigan versus Randall Franks, 251593. An appearance for the people, please.
Good afternoon, Your Honor. Erica Moses on behalf of the people, 78191. Good afternoon, Judge DeAnne Patillo, P 82378 on behalf of Mr. Randall Franks, statement of the court.
Randall Franks.
All right, thank you. Today's the date scheduled for a preliminary examination in this matter. And first, the court will note that neither party has submitted any witness or exhibit list per the court order that was signed and sent out on November 20th of this year. But in any event, what is happening today?
I apologize, Your Honor. I was not here for PCC. I'm not usually in front of Your Honor, but from now on, I will abide by Your Honor's order.
Okay, well, and quite frankly, whoever the attorney was that was appearing on your behalf should have submitted that information to you. And I will also note that the order that was signed indicated it was Mr. Mohammed.
I will have.
So, and it was not you, counsel. So, but for whatever reason, it would have been emailed to Mr. Mohammed. So, we somehow did not have your specific information, and I missed that on the order when I signed it.
Yes, Your Honor. And I apologize for that confusion, and I will make sure it doesn't happen again.
Okay. And so what's happening today?
So, Your Honor, the primary witness in this case is a 16-year-old minor child. She was currently, or at the time, staying with Mr. Franks. However, at this time, the child cannot be located. She's either with stepmom, who is in, we believe, Inkster, or with biological mother in St. Helen. The detective in charge, Detective Carr, was unable to locate her in time for service of this subpoena. However, I have contacted our Wayne County prosecutor, investigator, go to Inkster, as well as make contact with that St. Helen address to see if she is found. I'm unable to proceed at this time, Your Honor. I could technically bind over, the thought was to bind over fellowship proofs under people be only. However, down the road, that could lead to problems for me if I have not made contact with that child, Judge. And frankly, I do want to make that contact before moving forward, Judge. So for those reasons, I cannot proceed at this time. Though I did let Sister Counsel know that should we make contact with that child, should she want to proceed, that I will be immediately rewriting this case.
So let me ask a couple questions, counsel, before I give you an opportunity to respond. When were attempts made to locate the minor child?
May I look at my email from the Judge?
Yes, you may.
Subpoenas were sent to OIC December 12th. And then from there, I have email correspondence from the officer in charge that several attempts, and the victim advocate, Ms. Laura Dodge, also attempted to make contact as well. I tried calling the numbers listed in the report for the stepmom in this case, who's not an eyewitness, but is named in the report. I called twice, was unable to get in touch with her, left voicemail both times. Ms. Laura Dodge, the victim advocate, also put a note here that she attempted to contact the complainant and left a message as well. Officer in charge responded to 2 emails from advocate Laura Dodge over the weekend from Detective Carr indicating that he himself drove by the last known residence of the witness as well as the stepmother on 2 occasions. And then sent a car as late as yesterday, Judge, by the house and said that it appeared no one was in the home and no one was responding to the phone calls listed for that address as well.
Where is the minor child enrolled at school when this incident is alleged to have occurred?
I do not have that information.
Anybody contact the school district that she was enrolled in?
No, but that will be done once I get that information. Officer in charge and whomever the Officer Guzman also made contact with the child, spoke with her, but did not get that information at the time of the taking of the report. When I issued the report, I attempted to make a phone call as well. However, I was unable to reach stepmom and I left a voicemail as well, but I decided to sign anyways.
All right, Ms. Patillo?
So, Your Honor, based on the inability to locate the complaining witness at this time, I would ask that the matter be dismissed. I do understand that if she is located, that the state also has the opportunity to refile this matter, but I will be requesting a dismissal at this time, Judge. And Judge, if I may, my client hasn't had contact with the child, but it is his understanding that she's run away. And the high school that she was attending was Roosevelt.
Why would your client believe that she's run away?
If she's not with her stepmother or her mother, then the only thing she could have done is ran away. She attempted it one time before I received custody of her. She ran away multiple times from her mother's house. That's why I ended up with custody of her.
So is she reported as a missing child?
I don't know. I haven't had contact. But at this point in time, I'm a worried father. I don't know where my daughter is.
And Judge, as of this morning, a new CPS referral has been made to attempt to help locate that child.
What's the CPS referral going to do to help locate the child?
If she's in foster placement or in another placement, they may have that information, but I was not updated prior to. I did make contact with CPS if there are currently CPS referrals, and to my understanding, there's a case open as of depending on this case being charged, but I don't know status at this point.
So there's a pending CPS case as a result of this case, and there isn't any information on that case either?
I don't know if it was in regards to this case or it was open previously, Judge. The opening of that, I'm not sure, but procedurally, our victim advocates do make a new CPS referral when I charge the case.
Judge, I do know the last report that I have that was made to CPS was November 10th. And I do know that they have, I believe, 30 days to investigate. So we didn't know if that particular referral was still open or not.
Okay, so here's what I'm going to do. I'm not doing anything right now until I get information on that current CPS status, the current CPS case status from November 10th, because we're past that 30 days now. And my concern at this point is for the status of that child. Where is that child, right? At least let's figure out where she's at. One way or another. Okay, so we're going to take a brief recess and then we will recall this matter. So,
I have an exam in 33rd.
do you want to zoom back in? What time's your 33rd exam?
1 o'clock.
Okay. Do you want to zoom back in from there?
I can do that.
Well, okay, so here's what I'm going to do. We can even have you present on Zoom as well. So you're not going to be kept in the dark with anything. The concern that this court has, I'll just tell both of you right now, we're still on the record, right, Allie? Okay, is that I'm not inclined to dismiss it. I'm inclined to set an adjourn date. I have some serious concerns for the safety of the minor child, wherever she may be, whatever that may be. So I'm not looking to adjourn it months out, counsel. But given that I set this November 20th and attempts were just made December 12th, is a little bit concerning, even though was over a week ago. It was almost 2 weeks ago. But also, given that there's a current CPS case, the status of this child, or the location of this child should be known to somebody, or somebody is not doing their job within the CPS department. So that's where I'm at this particular moment. So, but before we do anything, we need to see where this child is. Okay.
Okay, can I address bond when we join the Zoom?
Yes, you can do it then. That way you can get over to 33rd.
Okay.
Okay. All right. Thank you. Let's go off the record. Okay. All right. So, let's go on the record in the matter. We're recalling the matter of Randall Franks, 251593. Appearance for the people, please.
Good afternoon, Your Honor. Erica Moses on behalf of the people, please 78491.
All right, thank you. And the court did give you permission to remove your coat and you don't have your suit jacket as you had coffee spilled on it.
Yes.
And Ms. Patillo.
Good afternoon, Judge Deanne Patillo, P 82378 on behalf of Mr. Franks. Mr. Franks, state your name for the court.
Randall Lee Franks.
Okay, very good, thank you. The court had taken a recess so that Madam Prosecutor could contact the CPS worker that's assigned to the case from the report dated November 10th, because there seems to be an inability to locate a 16-year-old, the 16-year-old witness in this case. And so, Ms. Moses, what was it that you were able to find?
Yes, Your Honor. The victim advocate in this case, Laura Dodge, was actually able to find the caseworker name and reach out to that person. The last contact from CPS with the child was December 11th. I'm subsequently given a phone number for the biological mother of the child, who is located in St. Helens. That child is with the mother at this time. She's currently enrolled in high school over there. She's in her junior year. She has had no contact with the defendant in this case, and the last time she has seen the defendant is the date of the incident. I do have the CPS worker's contact information, as well as supervisor contact information. If Your Honor is inclined to still grant an adjournment request, I would have to organize transportation. That's the only issue. I'm happy to pick her up myself if need be, but she's 3 hours away. And the mother does not have a driver's license. So in order to get her here, I'll need to fly her here or drive her here at some point, but I'm happy to do so to get her here. She does want to cooperate. She does want to testify in this case.
Okay. All right, Ms. Patillo.
So, Your Honor, if we're going to adjourn this matter, I would object to that. But I do understand that the complaining witness has a right to be heard in this matter. I would ask, if the court does adjourn this matter, that the court allow me to argue bond.
Okay, I will certainly allow you to argue that, but Mr. Frank, so now you understand, now you know where your daughter is. She doesn't seem to be missing. There's been contact made by the CPS worker about 2 weeks ago.
Okay.
Okay, so she's not missing.
As long as she's okay.
All right, so based on all that information, the court is not going to grant the request for dismissal of this matter, as now that we know where the daughter is, and given that she is not a close distance, which could have somebody go pick her up and bring her here for the testimony today, the court does find that would be good cause to grant an adjournment. So the court's not going to dismiss the matter, but will grant the motion to adjourn. All right, we can adjourn this to January 8th is not a good day, but I don't know that we can go much further than that. Oh, that's a special prosecutor. It doesn't have to be a Thursday. Can we do January 6th?
I am unavailable that date.
Okay.
What about, oh wait, the 6th. So,
That's a Tuesday.
Yeah, can we do it I'm sorry, I was looking at the 5th. I have a sentencing there at 1 o'clock on Zoom, but can we do 2 o'clock for the exam?
Well, could we do all of it at 1 and just be in person for the sentencing? Your
Yes,
client can still be on Zoom if that's what your client, if you would prefer for your client.
I just don't remember why. Yeah, we can do that though. If I do have an issue, I'll contact the court, but that should work. So I'll just put this down for 1 o'clock on January 6th.
Okay. Or we can even do, can we do 11 a.m. for the exam?
The only issue, Judge, is I have a 9 a.m. and 36th district court exam and they run very slow. So I'm just concerned that I can be there for a few hours.
Okay, so would 1 o'clock work for you?
Yeah, I can make that work.
Okay.
Yeah, I'm up with that whole morning.
Okay. All right. And so, counsel, you want to address bond. Bond is currently $50,000, 10% bond with a whole slew of conditions. Those conditions being no contact with the complaining witness, not to enter the premises on 23rd Street unless the victims move back with her mom, and that's been verified. So that we can amend. No contact with the prosecution witnesses, not to possess or consume any alcohol or drugs, no possession of a firearm or a weapon, GPS alcohol tethered through the Wayne County Jail, not to have contact with any dogs or other animals. Those are the conditions.
So, Your Honor, I would mainly be addressing the bond amount, the 50,000, 10%. Mr. Franks is not able to post that amount. I would be asking if the court would consider a personal bond in this matter. Mr. Franks does have a criminal history. From what I can see, his last conviction was 2016. I understand it was assaultive, but the prosecutors verified that the complaining witness is 3 hours away. Mr. Franks is not a flight risk. I don't believe he has a failure to appear history, Your Honor. Hopefully that's correct. Danger to the community. Like I said, the complaining witness is 3 hours away. I think that this was an isolated event between him and his child and his animals. Mr. Franks does need to pay his rent to preserve his housing. So, Your Honor, I would ask if the court would consider a personal bond along with those tethers.
A response from the people, please.
Your Honor, just to clarify what that criminal history looks like, there are 2 counts of assault and battery convictions from 2003 and assaulted. There's a 2012 conviction of felonious assault as well. I'm sorry, there's 2 counts of that in 2012, Judge, and then sister counsel is correct. In 2016, there are 2 misdemeanor domestic violence convictions. I have no concern for the child witness at this time, given the fact that she is separated from the father. I don't believe this individual will have contact with children, but I ask that if you do lower bond, you make it so that he cannot have contact with any children under the age of 17, Judge, but I leave it in your discretion ultimately. I don't see a failure to appear history, and I think he'll be here on the 6th, and we'll be able to proceed at that time. Oh, I will say, Judge, also, there was no serious injuries to the child. I did ask her what those look like, and she said there was some bruising that I believe we have photos of. If not, I will provide that to sister counsel. And the dog was removed from the home as well. It is with a relative, but the child is unfamiliar with the status of that dog at this time, but it is not with Mr. Franks or on it.
Okay. So, Mr. Franks, the individual, the victim in the matter from 2003 in Roscommon County, who is the victim in that matter?
That was somebody that I went to school with. We had a schoolyard fight. We were just getting out of high school.
Okay. So
Actually,
what about, hold on, sir, hold on. I'm just going to ask for names or relationships, not a whole dissertation as far as what occurred. So that was January of 2003 was that charge, and you were found guilty November 5th of 2003. Then on November 4th of 2003, you had a felony weapons charge, which was amended, or you pled no contest to assault and battery. November 17th of 2003, also Roscommon County. Who was the victim in that matter?
The same parties. It
Same
was
person. Okay, no, that's okay.
Battles.
No, you don't need to explain any of that stuff. Who was the victim in the 2011 charge of felony malicious destruction of personal property? Who was the owner of the property that, I know ultimately it was Noli Pros, but who was the owner of the property?
I am not sure,
Okay.
honestly, Your Honor.
All right, and then in Roscommon County, 2012, felony assault with intent to do great bodily harm less than murder was nolle prost. Assault with a dangerous weapon, you pled guilty to, 2 counts of that. 2 counts of that were dismissed, and another felony malicious destruction of personal property was dismissed. Who was the victim in that matter, sir?
I am not sure, Your Honor. There was a party in the woods and things got out of hand.
And then also in Roscommon County in 2016, domestic violence, there were 2 counts, or there 2 different victims?
As far as I know, Your Honor, there was only 1 count, and that was an ex-girlfriend, and it was all over a broken window.
Then in 2000, hold on, sir. Then in 34th Circuit Court, high BAC malicious destruction of property, unlawful driving away of an automobile. It appears though it was all similar in time to the domestic violence. Who was the victim in that one?
I am not sure. I was trying to get away from an ex-girlfriend during a fight, an argument. I had purchased a vehicle.
What happened? No, sir, I just said I don't need the details. I just want to know names of victims. And so then September of 22 at Siegel County, you had a traffic offense that was charged. Did you ever resolve that matter?
I was unaware that there was a problem up there. That wasn't my vehicle that I was in. I was actually driving a company vehicle for the person I worked for.
Okay, you're not understanding. When I say I don't need extra information, sir, I just wanted to know if you took care of that. You were charged with operating while license suspended, revoked, or denied.
Yes, I took care of that.
Okay. So I'll say this, that the court does have some serious concerns for the safety of the public, given Mr. Frank's significant assaultive criminal history. And now in this matter, and while I understand that there are allegations and there's not been a conviction, the victim in this matter with these allegations is his own daughter. And I have some serious concerns regarding the safety of the public, and given Mr. Franks' numerous cases that are up in the area where the victim resides currently, the court has some concerns that he will go up to that area. So the court is amending the bond condition. So, sir, you may return to the home on 23rd Street. You may not go to St. Helens, Michigan. The balance of the bond conditions remain the same. I'm also adding that you're not to have any contact with any children under the age of 18 as a condition of your bond conditions. The court has taken into account that the prosecuting attorney does not have objection to an amendment of the bond. The court, as I indicated, does have concerns for the safety of the public, given Mr. Franks' assaultive criminal history. The court will note, as the victim is no longer residing with Mr. Franks, the court does find that the immediate danger to the victim does not seem to exist at that point. At this point, the court will amend the bond to be a $25,000 10% bond. And do you need a refresher, sir, on the bond conditions, or do you know what they are?
I know what they are, Your Honor. I've been playing it over in my head.
All right, we'll see you back on January 6th. Thank you.
Thank you. Happy holidays.
Thank you.
Thank you. Same to you. It should be the same. Oh, actually, it's aboggs@yn.mi.gov.
BOGGS.
Yes.
At
yn.mi.gov. Okay, thank you. All right, let's go off the record. All right, thank you.
Thank you.
Good morning or good afternoon in the Squally Jail. What is your name, please?
Madison Mary Rose.
And I show that your true legal name is Madison Reese Misha Mayrose, and your date of birth is April 27th, 1983. Is that correct?
Yes.
Ms. Mayrose, good morning. Or I keep saying that. Good afternoon. You are before the court in two different matters, both of which are scheduled for pretrial conferences. 21L000819 and 20S000014. Ms. Grisco, it appears that your law firm was the attorney of record previously in both of these cases, but there has been a prolonged period during which Ms. Mary Rose has been on warrant status, and during that time, I believe your law firm was withdrawn. What is the status of Horwath's representation of Ms. Mary Rose at this time?
Yes, Your Honor. In speaking with Miss Mary Rose, we did rescreen her and do believe that she qualifies. So we would ask to be reappointed for her case.
Thank you. Based upon that record, the court is going to reappoint the Horwath law offices to represent Ms. Mary Rose in this matter, or in each of these two matters. Court is going to order the execution of a promissory note in each of these two cases, subject to waiver upon the court's review of the eligibility screening sheet once that is filed by Ms. Grisco. Ms. Grisco?
Sorry, I had gotten a message that distracted me. I apologize.
That's okay.
For Miss Mary Rose, she would like to enter a plea of guilty to the malicious mischief. If the court accepts this plea, then to dismiss the criminal trespass in the second degree. We've gone over this document with her. She does understand that she's giving up many important rights, and that the court does not have to follow this recommendation. It could sentence her up to the maximum. She understands the consequences of immigration. I do believe that she is entering into this plea freely, knowingly, and voluntarily, and is ready to answer any questions that the court may have. Thank you.
Thank you. Ms. Mary Rose, I have in front of me a document that's entitled Statement of Defendant on Plea of Guilty. It tells me that you're 42 years of age. What it does not tell me is how far you went in school. What is the last year of school that you completed?
I think I almost have a bachelor's degree.
Oh, okay. Ms. Mary Rose, this document also tells me that you are asking to change your plea from not guilty to one count of malicious mischief in the third degree, domestic violence, as charged under case ending in 0819, and that if I accept your guilty plea, that the prosecution has agreed to move to dismiss the other criminal case ending in 0014. Ms. Mary Rose, is that your understanding of how you're asking to proceed this morning?
Fine.
I'm sorry?
That's good.
Okay. Ms. Mary Rose, have you had an opportunity, well, actually, before I go any further with that, Mr. Tuninga or Ms. Grisco, the charge in 0819 indicates malicious mischief in the third degree domestic violence. Did this involve an intimate partner or a family or household member?
One moment, Your Honor.
Thank you.
This would be an intimate partner based on the fact they were dating at the time.
Thank you, sir. Okay. Ms. Mary Rose, have you had an opportunity to discuss with your attorney all of the elements of the crime of malicious mischief in the third degree, as well as the special allegation of domestic violence and what that means?
Yeah.
I'm sorry?
Yes.
Okay. You understand what it is the prosecutor would have to prove beyond a reasonable doubt if that charge went to trial?
Yeah.
Okay. Paragraph 5 of this document lists out a number of constitutional rights that you are waiving by entering this guilty plea. Have you discussed the rights that you're giving up with your lawyer?
Yes.
Paragraph 6 of this document paragraph 6 of this document lists out what the prosecutor has agreed to recommend in the event that I accept your guilty plea. What they would be recommending is the sentence. They're recommending, 10 days in jail, credit for 5 days that you've already served, and the remaining 5 days to be served on the court's work crew program.
And Your Honor, I did just redo the calculations. It does appear she has 9 days credit, not 5 days credit.
Days credit, okay. So only 1 day on the work crew then?
Yes, Your Honor.
Understood. So, Ms. Mary Rose, is that your understanding of what the prosecution has agreed to recommend as a sentence?
Yes.
And you understand that is only a recommendation. The court is not required to follow it. The court could impose up to 364 days in jail and up to a $5,000 fine. Okay. You understand that if you are not a citizen of the United States, this guilty plea could have negative immigration consequences?
Yes.
Paragraph 11 of this document asks you to state in your own words what it is you did that makes you guilty of the crime of malicious mischief in the 3rd degree domestic violence. That statement reads as follows. On or around July 6, 2021 in Lakewood, Washington, I knowingly and maliciously caused physical damage to the property of another, and then the initials MM appear after that statement. Well, first let me ask Ms. Mary Rose. Ms. Mary Rose, that statement as it currently exists, is that an accurate statement of what you did that makes you guilty of this crime?
Yeah.
Okay. Ms. Crisco, I think we're going to need some additional language because that covers the elements of malicious mischief in the 3rd degree. What it does not do is provide a factual basis for the special allegation of domestic violence intimate partner.
Yes, Your Honor. I don't know if I cannot edit it.
I can't. You just have to tell me what you want in there.
Thank you. I knowingly and maliciously caused physical damage to the property of an intimate partner. Would that suffice?
Yes, I will need the name of that individual.
The individual in question's name is William Polston.
Thank you.
I can spell that last name.
Yeah, I'll get that from you in just, well, and one I just indicate of William Holston. Any objection to that in paragraph 11, Ms. Crisco?
No, Your Honor.
Of another, it'll say William Holston. Mr. Tuninga, how do you spell that, please?
William, and Polston is spelled Polston.
Thank you.
And they shared an intimate relationship.
Okay. So, Ms. Mary Rose, I made a slight change to that statement. So for the record, I'm going to read it to you one more time and you can tell me if it's true and correct. On or around July 6, 2021 in Lakewood, Washington, I knowingly and maliciously caused physical damage to the property of William Holston, a person that qualifies as an intimate partner. And then the initials MM appear after that. Is that a true and correct statement of what you did that makes you guilty of this crime?
Yes.
Thank you. Just a couple more questions for you. Ms. Mary Rose. Ms. Mary Rose, this guilty plea form, did you read it yourself? Did your attorney read it to you or both?
It was read to me.
I'm sorry?
It was read to me.
Okay. Did she answer all of your questions?
Yeah.
All right. You feel like you understand everything in this document?
Yeah.
Ms. Mary Rose, has anyone threatened you in any way or made any promises to you to force you to enter this guilty plea?
No.
You're doing this of your own free will?
Right.
Ms. Mary Rose, at this time, under case number ending in 0819 to the charge of malicious mischief in the 3rd degree domestic violence, How do you plead? Guilty or not guilty?
Guilty.
Or will accept Ms. Mary Rose's plea of guilty at this time. The court is satisfied based upon the record that Ms. Grisco has made, as well as the court's conversation with Ms. Mary Rose in open court this afternoon. It does appear to the court that she's entering this plea knowingly, intelligently, and voluntarily. Appears that she has had the opportunity to consult with counsel, understands the rights that she is giving up by entering this guilty plea. It appears to the court she understands the elements of the charge of malicious mischief in the third degree, the meaning of the special allegation of domestic violence, potential consequences of her plea. She has provided a factual basis for the plea in her plea form, and the court will accept her guilty plea at this time. Mr. Tuninga, anything further, and I appreciate the updated information. Anything further from the prosecution regarding the substance of the sentencing recommendation?
Your Honor, just for clarity's sake, that's William Holston with a P. I might have heard William Holston with an H.
I have it as P-O-L.
Okay, perfect.
I probably said that because I additionally thought you said Holston, but it is correctly spelled in the plea form.
Okay, my plea form isn't updating on my side, so I just wish to make sure it is correct. So, Your Honor, the recommendation of the prosecution is 10 days in jail for the defendant to be given 9 days credit, and for the remaining 1 day to be available to be done on work crew, Your Honor. And after that's completed, then the case should close.
All right. How much time is the prosecution recommending that Ms. Mary Rose have to complete that 1 day of work crew?
I believe it can be done in 1 month. So jurisdiction conservatively 6 months.
Thank you. Ms. Grisco.
Your Honor, given the length of time and the age of these cases, we do believe that this is an appropriate recommendation that was agreed upon both by the city and defense. Ms. Mary Rose wishes to put this matter behind her, and we do ask for the court to follow this recommendation. Thank you.
Thank you. Ms. Mary Rose, you have the right to make a statement to the court before I impose sentence. You do not have to say anything. I'm not going to hold it against you if you choose not to make a statement, but you do have that right. Is there anything you would like to tell the court before I impose sentence?
No.
I do want to note for the record that I'm granting the prosecution's motion to dismiss the other case, 20S000014. That matter will be dismissed with prejudice at this time on the motion of the prosecution. Court is going to follow the recommendation of the attorneys in all respects. Court is going to impose 10 days in the Nisqually jail. Going to give Ms. Mary Rose credit for 9 days that she has already served. I'm going to order her immediate release from custody. I'm going to allow her the opportunity to serve that one final day on the Lakewood Municipal Court Work Crew Program. Court is not going to impose any legal financial obligations. Court is going to indicate that the matter will close once I receive, or the court receives, certification from the probation department that 1 day of work crew has been completed. Court is going to schedule a report date. Ms. Mary Rose, you have to meet with our probation department. They will then schedule that 1 day of work crew, and when you're going to be able to do that. I'm going to go ahead and schedule that for, let's see here. Let's go ahead and get that on the books sooner rather than later. I'm going to go ahead and schedule that for December 29th. Is that Monday? Okay. We're going to go ahead and schedule that appointment for Monday at 1 p.m. here at the Lakewood Municipal Court. You do need to appear in person and on time for that hearing, or not hearing, appointment. Failure to appear at that appointment will result in the issuance of a bench warrant for your arrest. Okay. Court has signed that judgment and sentence. Ms. Mary Rose, that will conclude your hearing. You should be released here in the next few hours. We'll see you back here on Monday, this coming Monday, for your probation appointment at 1 p.m. Okay? Thank you. Good afternoon in the Nisqually Jail. What is your name, please?
William Polstein.
And Mr. Polston, I show that your date of birth is March 22nd, 1991. Is that correct?
Correct.
All right. This is case 20L002128. Mr. Polston is before the court for a pretrial conference in this matter. Here's the matter was last before the court. Back on December 19th, 2024, so just over a year ago. Ms. Crisco, it does appear that your firm is still the attorney of record. How would you like to proceed with the pretrial conference?
Your Honor, since we have not seen Mr. Polston for over a year, we would have to rescreen him. In addition, with the fact that we do have a conflict, we would ask to appoint conflict counsel.
All right. So it sounds like the request is for a continuance for new counsel to be appointed. Is that correct?
Yes, Your Honor.
All right. Mr. Tuninga?
City has no objection to the continuance request based on the request for new counsel. City would be requesting either no change in conditions of release or bail be imposed in the amount of $2,500 based on the nature of the charge and the time it's been since we last saw the defendant.
What is bail currently set at?
Good question, Your Honor. $2,500.
Thank you. Ms. Crisco?
Your Honor, we would ask for Mr. Polston to be released on his personal recognizance and for no bail to be set, with the fact that he did qualify for a public defender previously, and there's no indication that his financial situation has changed, that he would more than likely be still found indigent, so that he can have time to talk with Mr. Resnick about his case. We would ask for him to be released to be afforded that time before he had his next trial. His next hearing, apologies.
No worries. Yeah, the court is going to grant the prosecution's request. I do note that arraignment in this matter took place on January 19th, 2021, so just under 5 years ago. The reason the case is still pending is because it appears like every time that Mr. Polston is released, he subsequently fails to appear. So the matters have been on prolonged warrant status just time and time again. So the court has a great deal of doubt that Mr. Polston would appear as ordered by the court if he were released on his personal recognizance.
Okay.
So the court is going to keep bail as currently set in the amount of $2,500 cash or bond.
Your Honor, I did upload a motion to continue. I'm just unsure what date I should set it at.
Yeah, that's no problem. We're going to go ahead and go with, since we're holding him in custody, what's that? Oh, yeah, we can do that. Yeah, we'll go ahead and set this matter for next Friday.
Okay.
That'll be January 2nd at 11 a.m. And I'm going to grant Ms. Grisco's motion to withdraw due to conflict. And will appoint Matthew Resnick to represent Mr. Polston in this matter going forward.
I don't really understand what's going on.
So, Mr. Polston, long and the short of it is, what is happening at this point is you've been represented for the past 4 years or over 4 years in this case by the Horwath law offices. But the problem is, between the last time you were before the court and now, they have developed a conflict of interest. So they can no longer represent you, which means that I have to appoint a new attorney to represent you, and that's going to be Matthew Resnick. So he's going to be in contact with you between now and your next hearing date, which is Friday, January 2nd. That is 1 week from today, to discuss with you what your case and what the plan will be going forward. Okay?
Am I going to be released?
Well, the only way you're going to be released is if you post bail. You will have to post bail in order to be released.
I can't get released by my own cognizance?
I'm sorry, Mr. Polston, what was that?
If I get released under my own cognizance, and I can come to the next court date.
Yeah, your next court date, if you're still in custody, will be 1 week from today.
Well, if I get released under my own cognizance, then.
Yep, I'm about to give you that. So you're out of custody court date. Let me find that really quick. Yep. That's going to be February 5th, 2026 at 1 p.m. All right. And the court has signed that order. Mr. Polston, thank you, sir. You can go ahead and let the officer know that you're all done. If you're still in custody, we'll see you on Friday of next week. Otherwise, we'll see you here at the Lakewood Municipal Court on February 5th, 2026 at 1 p.m.
So there's no way I can get released under my own cognizance?
No, you're not being released on your personal recognizance. You are only going to be eligible for release if you post bail in the amount of $2,500 cash or bond.
Can I talk with my attorney for a little bit, please?
Your attorney is now Matthew Resnick, and you would have to call him from the jail.
How to get a hold of a bail bondsman?
They have that information available for you there at the jail.
Thank you.
Thank you, Mr. Polston. You can go ahead and let the officer know that you're all done.
Understood, Your Honor. I will pass that along.
Okay, thank you, Ms. Moore. And Ms. Squally, your name, please.
My name is Harold Jaramillo.
Thank you, Mr. Jaramillo. And Mr. Jaramillo, did you go over your constitutional rights with Mr. Swenson?
Yes.
Have any questions for me about those rights?
Any what, sir?
Questions for me about those rights?
Oh, no, sir.
All right. And Mr. Jaramillo, I'm showing an address of Military Road.
Yes.
Okay. And Mr. Swenson, did we get a cell phone number?
I did, Your Honor. I'll provide that to the court.
Thank you. And Mr. Swenson, any objection to probable cause?
No, Your Honor, not for the purpose of today's hearing. Defense will stipulate and ask to enter a plea of not guilty. And Mr. Jaramillo is seeking court-appointed counsel, Your Honor. He is working, making about $2,600 a month, but pays child support for 2 children.
Okay. And what are you bringing home after the child support is taken out, Mr. Jaramillo?
I bring about anywhere from $1,200 to $1,300 every 2 weeks.
Okay. And is child support taken out of that, or that's what you have left after child support's taken out?
That's what I have left after child support.
Okay. Thank you very much. will appoint Pacific Point Defense to represent Mr. Jaramillo. And based on Mr. Jaramillo's income, I will order Mr. Jaramillo that you pay $125 to help defray taxpayer expense of providing service of counsel. See a bunch of alcohol-related offenses, but I don't see any prior DUIs, Mr. Sharp.
No, our city's aware of 2 priors from Oregon, 1 conviction 2001, 1 from 2003.
Okay, thank you. City's position on release.
Your Honor, I've reviewed this case 3 times today, and every time I look, it's a little worse. City's asking for $25,000 bail, law-abiding behavior, no driving without a valid license and insurance, no consumption of alcohol, marijuana, and non-prescribed drugs. Mr. Jaramillo not go to any bars or taverns, not refuse any breath samples if requested by competent law enforcement. So he's also asking for a scram device and ignition interlock. The bail is a hefty request. City believes it's necessary at a minimum. City has concerns over the likelihood of future violent crimes to include potentially vehicular homicide or vehicular assault. As mentioned, he has those 2 prior DUIs. That's against a background with quite a bit of other criminal history as well. But the facts in this case are quite concerning. It's from yesterday, Christmas Day, about 8:30 p.m. Having read through quite a few statements here, as well as several officer narratives, I'll just try briefly to summarize it. Allegation: we had a young father and a young mother with their baby in 2 different vehicles out on Martin Way, getting ready to turn left with a green turn light. The father was in the first vehicle and went ahead onto the on-ramp to I-5, I believe it was. Mother and the baby were right behind. This is a 13-month-old baby. As they were turning left, and as observed by the next car behind them, who provided statements, Mr. Jaramillo blew through a red light, went straight through the intersection and plowed into that car. Sounded like it was a fairly substantial hit. One witness here, Heather, sorry, I want to catch her last name, but the handwriting's hard to read, Your Honor. I'm just going to say Heather for now. She writes that he slammed into the victim's vehicle, proceeded to keep going until he slammed into the victim's vehicle again, and his vehicle would no longer run. They pulled over to make sure that the victim was okay and to check on Mr. Jaramillo. He attempted to start the vehicle and realized he couldn't. He then got out of the vehicle, asked what happened. They told him and that he was drunk. He was clearly drunk, she says, stumbling, slurring his words. In the process, lost his shoe, found it, and then walked off into the woods as the cops showed up. Officers were unable to find him until a bit later. A state trooper responded to a call of a person running across northbound and southbound I-5. Responded, found Mr. Jaramillo there with debris and brush attached to his clothing. Officer arrived. He matched the description given. One of the witnesses was driven out for a field show-up and positively identified him. Breath sample was provided, 0.15. So we have 2 prior DUIs.
How long after the accident was the contact?
It was, just a second, we've got a report from a trooper here for that. Looks like it was about 40 minutes or so later. And that was a good half hour or a half mile away from the scene that he was then apprehended. So we have this accident that, we are very lucky that that was not a vehicular assault or a homicide, especially with that baby in the car. The attempt to flee first in the vehicle, when that didn't work, he fled on foot. And then the high BAC, all this in mind, city believes $25,000 is a fairly modest request.
Thank you. Mr. Swenson?
Well, Your Honor, the city has changed its position several times today, reviewing the case. And so let me just say, I haven't been able to discuss the city's most recent position with my client, but here's our position. So I did discuss the possibility of heightened conditions, given the history that is quite old out of Oregon. That's over 20, those DUIs are over 20 years old at this point, Your Honor. We were going to agree to heightened conditions and to have that scram imposed. The city wasn't originally asking for that, but I understand they've changed that position now. I don't think that the fact that this was a close call, to be quite frank, Your Honor, any DUI, any alleged DUI has the possibility of being much worse. It has the possibility of being a vehicular assault. I don't think just because there was quote unquote a close call in this case that necessarily means that we need to impose heightened bail in this specific case. It wasn't worse. The allegations here are simply DUI, not vehicular assault. Mr. Jaramillo, Your Honor, has criminal history. He acknowledges that criminal history. In Washington, it's over 10 years old at this point. It's not DUI related. The DUI out of state is over 20 years old. Mr. Jaramillo has completely turned his life around in the last 10 years. He is working. He's working to support himself and his children. He has a fiance who works, so she supports herself, but he's completely turned his life around, Your Honor, and he's not going to be able to post any more than what is currently set, which is $2,000, $1,000 on each count, I believe. And if he's not able to post and get out, he's going to lose his job, and things are going to, spiral, I think, from there for him. He is able to post $2,000. My request originally was going to be PR with the heightened conditions. Based on the city's new request, Your Honor, I'm going to ask the court to keep bail set at $2,000, which will require Mr. Jaramillo to post something. He can post that. He's indicated to me he won't be able to post any more than that. And then if the court imposes those heightened conditions, I think that should be sufficient to ensure his non-consumption and that we don't have any potential issues with community safety. As long as Mr. Jaramillo remains clean and sober, I think there shouldn't be any concerns. So I just wanted the court to be aware. We are aware of the history. We are aware that it's very old. Mr. Jaramillo has turned his life around, and we're seeking his release today so that he can work on this. He's taking this seriously. He will take this seriously, Your Honor. And we just ask the court to give him a chance and to leave bail set in a reasonable amount, allow him to post, and set those heightened conditions.
All right, thank you. There's fairly substantial warrant history, but no active warrants. I'm assuming, Mr. Sharp, the city's request is based principally on public safety issues.
Your Honor, the city does believe there's an angle on the flight prong as well, given the effort he went to flee the scene there.
Okay. All right. I'm going to agree with the city on this one. And I'm persuaded by a couple of facts that have been put before the court. One is the charge of hit and run, and Mr. Jaramillo and his alleged attempts to escape the scene, not willing to accept personal responsibility for a potentially really dangerous accident, potentially really destructive. But his attempts to flee, not returning to the scene at all, and caught when he's trying to get across I-5 in a really dumb decision. And the fact that there are 2 prior DUIs, and also the driving pattern alleged in this case, which is, this isn't a close, is it yellow, is it red case. This is a car has already gone through the intersection, and Mr. Jaramillo then plows through the intersection against the light, allegedly, and hits the second car. That greatly raises the stakes on the driving pattern in this case. So I think the bail is warranted from principally a public safety standpoint, but also because of the hit and run allegations and the warrant history from a return to court basis. So $25,000 cash or bond. I will appoint counsel to represent Mr. Jaramillo. I've ordered Mr. Jaramillo to pay $125 up to Frey Counsel. Mr. Jaramillo, no alcohol at all, period. No marijuana. You are not to enter any bar or tavern. Do not refuse any breath test. Don't drive unless you have valid license, insurance, and ignition interlock in any motor vehicle. If you post bail, you are required to get a scram alcohol monitoring device within 48 hours of release. You are also required to report to pretrial services within 48 hours of release. Your next court date?
Your Honor,
Yes.
defense, I know unusual request, but defense would ask to set a pretrial hearing on Tuesday, next Tuesday. Mr. Jaramillo, based on my conversation with him, is not going to be able to post bail at all. I want to be able to review the offer with him. I understand that my office could set him on Monday, but I just want to, if able, I want to set him on Tuesday just to make sure we can touch base.
Yeah, I'm going to do a little differently. I'm not a fan of putting cases on the calendar if we don't have a known reason to do so. I know that there's perhaps anticipation, but to me, that's not good enough. We fill up our calendars too much that way. I'm going to schedule it for Tuesday, the 6th of January. If you get it done sooner, you can get it on the calendar. But right now, the next court date will be the 6th of January. And based on the information that Ms. Jaramillo is not going to be able to post, I'll put that straight to the 1:30 calendar on Tuesday, the 6th. All right. Thank you.
Sorry, one last. Go ahead. I would request, just in case there's a change, I'd request to put it on the morning calendar. We can always move them over easily on the 6th.
Okay, I'll put it on the morning calendar. What time in the morning calendar?
We'll do 8:30.
Okay, 8:30 on the 6th of January.
Thank you.
Thank you. All right.
So,
Yeah, you're free to go, Mr. Jaramillo. We'll be in touch.
Mr. Bowman, come on up and take a seat.
Thank you, Your Honor.
Okay, this is, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth. Just one at a time there, Mr. Fasano. When it comes to you, I'll speak with you. Swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down.
Thank you.
And so I'll be frank with you and Mr. Fasano. This is a little bit of an unusual type of case we have here. So you signed up to take a class from truck driving school, and now you want your money back. Is that basically what's happening?
Yes, Your Honor.
How are you entitled to have that money back?
Your Honor, I initially enrolled and paid $2,500, which was half of the total $5,000, and that was for 2 weeks of instruction. In the circumstance, I did not receive anything near 40 hours during the first week or during the second. The circumstance, when you first arrive, you sign on a sign-in sheet, and when you leave, you sign out. In the first week, even though it said 4 o'clock is when I signed out, typically I left at noon or 11:30. The instructor, Cody Armstrong, did not show up at 8 o'clock. He typically came in I gave some information there, but he was very rarely there for more than about 2 hours.
So you did not complete the course?
No, sir.
Okay, keep going.
The circumstance, it was very frustrating to me. Never during the first week were we allowed to go out and actually look at any of the trucks or get introduced to the pre-trip inspection. That came in week 2. It was a very frustrating experience for me, sir, because I had never driven that kind of vehicle before. But essentially during that second week, and the other thing that was not made clear to me when I first started, I was not told that there were other instructors that were on vacation that week. It was just the one instructor, Cody Armstrong. And it was, I think, Wednesday or possibly Thursday of week number 2. One of the instructors, who was apparently not pleased with how I was performing in terms of backing the truck in a straight line, suggested I go down to their facility in Chehalis, where another one of their instructors was. So I went there. It ended up being an absolute waste of time, even though when I got down there and met the individual, and that individual said, "You obviously have the pre-trip inspection down absolutely perfect. But then he left, the other students left. I mean, the particular truck, just to give you an idea what that company is like, the truck that I did the pre-trip inspection on was a non-functional truck. And it was obvious to me it was just a waste of time and likewise additional cost to go down to Chehalis on a daily basis. It was very frustrating on that day. At the noon hour, everybody had left the facility. I went back out to my car in the parking lot. I had my checkbook. I called the credit union I have an account with and canceled the check for the second half of the course. And at that point, just drove home. There was nobody in the facility.
If you'd have gone through the second half, would you have was there a certificate to be given at the end of it?
Had I gone through the second half, yes, the idea for getting a CDL, and I went through the written tests with the state earlier and passed those in my first attempt.
Okay.
The circumstance, Washington requires one of the most exhaustive practical tests as a demonstration of skills that essentially is irrelevant into the real world, not backing around a corner. For
okay,
example.
so
at any rate, I was never given really adequate.
Is that what you took the class for? Was to learn how to do the things to pass the Washington driving test?
Yes, sir.
Okay, and then when you went to, if I understand you correctly, when you went to Lewis County, then were they going to teach you how to do that, or what exactly? You said I thought you said one of the instructors said, well, they weren't really pleased with how you did that, and so you're better off in Lewis County doing that. And it's not clear to me why, in your words, that was such a waste of time.
Your Honor, I did go to, as I mentioned, I did go down to their facility in Chehalis. They had just one instructor there.
Okay.
And it was obvious to me, it just wasn't worth my time. They didn't have operational equipment, or what I was showing that they had operational equipment there. And I mean, again, as I mentioned, I did the pre-trip inspection on a non-functional truck.
Well, I mean, that might, okay, I'll hear from him in a minute.
But the circumstance, it was a complete waste of time for me to go to Chehalis. And it was a very frustrating experience from my perspective. I was just not given adequate opportunity.
Okay, let me hear from Mr. Fasano. Mr. Fasano, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. What's your position on, what's your response to what we just heard from Mr. Bowman?
All right. So, Mr. Bowman, what he signed up for is a 160-hour course. He signed a contract before he began to let him know that at these different points in the course, this is how much you are entitled to as a refund. At the end of that first
week, say that again, 160-hour course, did you say?
Yes, over the course of 4 weeks.
Okay.
During that first week, you're entitled to 90% of your tuition back if you leave during that first week. Past that first week and into the second week, you're entitled to 25% back. Between that and the end of week 3, you're entitled to 25% back. And then we're entitled to all of it if you get to the end of that and we are, you are still wanting to leave. We're entitled to the entire amount based on the contract, which is stipulated by the Workforce Board, the State Workforce Board, and the Department of Licensing. They both approve on the contract.
Is that contract in here someplace?
It is not. I have it with me. I can send it. I had it ready, but with the Christmas holiday, I was out of town and did not realize that there was a 1 week stipulation for the middle. And I did not realize that until this morning as I was preparing. I do have it with me, but it is not submitted.
Can you email it? Can you email it to us?
Yes, I sure can. If I have an email, I can get it to you in just a few seconds.
So I'm gonna take a look at that and then I'm gonna print it off and I'll have you look at it too.
Certainly, Your Honor. I'm just chuckling a little bit, and they were serviced with this.
Well, I mean, yeah, he was served a long time ago, but you know, small claims are informal hearings. And so it would help me to look at the contract. Yes, of course, he could have got it here earlier. But it's
I do
not,
apologize
but
for that.
I still think it's important to look at it.
Should I
So hang
continue
on just
while
a
we?
minute there. So go ahead, yeah.
I just added it in the chat.
You should have just got an email in the chat there.
It should be on its way here in just a moment.
So how much is it for the whole course, the whole 160-hour course?
So it actually just updated when Mr. Bowman was going through the course itself. The tuition, what comes to Washington Trucking School, was $5,000.
Okay, well, talk to me, respond to what Mr. Bowman described as his experiences at the school.
Yeah.
Apparently he wasn't satisfied with what he was getting.
So part of that
was county thing, which frankly, I haven't quite figured out what went on there and why that was a waste of time, but go ahead. Let me hear from your perspective.
So the first week is a purely theory week. And part of that theory, there's really three things you can do during that week. You can do our one-on-one or, one-on with the class theory instruction, which is led by an instructor. You just kind of lecture review, show videos, shows slideshows, your quiz, that sort of thing. In addition to that, you can do pre-trip inspections and you can study for your commercial driver permit. So those are really the majority of what you're going to be doing in the first week. Lawrence was given an opportunity to work on his pre-trip during the second half of the day. Every student is given the opportunity to work on their pre-trip during the second half of their first week, which is the theory week, where you sit behind the wheel of the truck and you do a inspection to essentially make sure that everything is working properly. In both schools, our Chehalis campus and our Olympia campus, this is done on a truck that is not road registered. It functions, it turns on, it can shift gears. It won't go down the road because usually there's usually some sort of issue with that truck, which is why it stays in the yard. It's just there for pre-tripping purposes to practice, because it is just like the truck that you're going to be driving and pre-tripping on it. So during the first week of his education, there were 3 instructors present. One instructor was on a pre-planned vacation, but they had the ability to do pre-tripping. A lot of pre-tripping does not require one-on-one instruction. A lot of it is you just going through the list of items that you're supposed to be going through and marking off or calling out or pointing to, and doing rote memorization. That does not need an instructor to be hand-holding you that entire time. So a lot of that is just, students in both at the truck in different various stages of their pre-trip doing practice. Lawrence chose not to participate in this and left early during that first week while marking his time out as 4 p.m. If we come to know that, generally as a school, we add time to the end of that student's course to make up for the time that they have missed. Because it is legally required that they be there for 160 hours. In addition, the reason why he was sent down to Chehalis is because when he did enter a truck and we were beginning, week 2 is backing, so you do get into a truck, but you're mostly just backing there in the yard. Week 3 is where you start to get out into the field. You're doing actual on the road driving, and it's where it can kind of get scary for new students. This is where Lawrence started to struggle. He was not able to do the straight line backing maneuver even after a week of attempting to learn. He was unresponsive to instructors when he was asked to do things like hit the brakes and stop in the yard. He would often roll 25 or 30 feet before he would actually come to a full stop. So this becomes a safety concern for us. We have to make a decision at this point, like a jumping off point for us, where we decide, is this student going to make it as a driver, or is it going to be a safety issue that we have to nip in the bud now before we get him a certificate? One of the ways that I do that is we do have 2 campuses and we have several instructors at each campus. I like to get an additional perspective. I send the student from one campus to the next, and I will usually offer to pay for fuel so that it's not a complete waste of time for them. I didn't really get a chance with Lawrence, but we do that so that we can get a different perspective and see, is this student really struggling? Is it just the instructor's manner of teaching? Does this student just not really learn well from this instructor? I don't like just, saying, hey, here's the door, and that's that. I like giving them an additional chance to show that, hey, with the right instruction, maybe we can make this work. Lawrence showed up, even though he had opportunity to arrive earlier. He showed up at 11:30, which is right about the time we began our lunch. So an instructor still took their time, went over the pre-trip with him, and then everybody went to lunch. Lawrence decided to take that time to cancel his check, leave the facility, and not come back.
I have a question for you. Hang on just a second. So how long was he in your facility? Was it 1 week?
So he came down to the other facility. He was only there for about 30 minutes, but this was, I believe, the 3rd day of his 3rd week. So this would have been
3rd week.
2.5. Yeah, so 2.5 weeks into the course.
Okay. Let me come. So how many hours did he do there?
Well, I mean, now that I know he only showed up half days for the 1st week, it's going to be kind of hard to make an accurate estimate there. But according to the timesheets that he signed, it would be roughly 90 to 100 hours.
Okay. So he's telling me, so thank you. So when I read what you had submitted, I was under the impression that you were only there a week.
I was there for, it was in the 2nd week that I ended up going down to Chehalis, not the 3rd. One of the things,
so hang on just a second. Go ahead and say that again, Mr. Fasano.
I may have been wrong about the date that he left. I'm going to double check with my timesheet to see, because I do have a timesheet here that shows me when he left.
Continue on.
The 2 points that I want to make, Your Honor, it was never made clear to me that in the 1st week, that in the afternoons we could go out and spend some time learning the pre-trip inspection with the trucks. That was never made clear to me. And again, essentially there was one instructor that we had that 1st week, Cody Armstrong was his name. He typically left the facility at the latest he left was 11:30. Most times he left around 10 or 10:20, something like that. It was very depressing in having less than 2.5 hours or so to speak, instruction each day. The circumstance, I picked up the theoretical material very readily and went to on that 1st Saturday.
He's telling me that's the reason why you went down to Chehalis, was because there was a concern about the operational aspect of it. And that's why, and again, if I understand him correctly, he's saying just, have different eyes on you, maybe respond better to a different teacher. Maybe the teacher up here didn't really, might disagree with, but they wanted to make sure that you were getting it, basically. That's what I'm hearing from, and then you're saying, well, that was just a waste of time. And I'm still not sure why you said that.
Well, let me just clarify that a little bit. Okay, so the circumstance in terms of the instructors that they had here in Olympia, the way the thing is structured, you only have about 2 to 2.5 hours each day. What they do is they split it up. There'll be, let's, for the sake of argument, say 4 or 5 students in sort of a waiting area, and one at a time. They will be taken out to the yard and allowed to get some experience driving the truck forward, trying to back in a straight line, that sort of thing.
And you got this instruction?
For 20 minutes, maybe a half an hour at a time, but then I would get out and one of the other students would be given access to it. But it was the sort of thing for each day I
How
would
many
only get.
times did you go out there and do that? Like say 20 to 30 minutes?
Well, I would only get about 2 hours of actual instruction each day.
Okay.
Typically, I would get 2 opportunities. There was only one day when I got 3 opportunities.
To get out there and work the truck
Right.
for 20 to 30 minutes at a time? Did you say?
Correct.
So that's basically, that's like an hour and a half or, okay.
That's my point.
All right. So Mr. Fasano, come back to you. How much time did he do here?
According to his timesheet, he was on day 12 or day 13. So he signed in on day 13, which would be 3 days into week 2, or sorry, week 3, as I initially stated. So he signed in that day, but never signed out because he left early, because he went down there. He did not receive the full evaluation. He was evaluated on his pre-trip, and before he could be evaluated on his driving or his backing or anything else, he decided it was a waste of time and left.
Okay. And so, had he just continued on, was there any reason why he wouldn't have been able to complete the course successfully?
Again, that was part of what we were doing, was trying to determine if that was a possibility, if it was something that he could do safely, because he was struggling to do it safely with the instructors that we had.
Okay.
In Olympia.
So if he's 3 days into his 3rd week, is that more than 50% of the?
It is, yes, but that's also based on the curriculum that we've sent to the state. This is the time where he's supposed to be entering the truck. You know, the backing week, the 2nd week, is usually when we start to get an inkling, because we can't really test them on, you know, the practical stuff during the 1st week. We're not allowed.
Right.
During the 2nd week, they're really just doing some backing procedures. They're still just getting familiar with the truck. They might be taken out to a shifting course where they can, you know, learn the general shifting pattern and kind of get practice with that. We usually take them out to a large parking lot over at Cabela's there in Olympia for that practice. But before they can get to that point, before they are taken out for shifting practice, they have to be able to back in a straight line and demonstrate that they're going to listen to their instructor. And Lawrence was not able to do either of those things.
Okay. So Mr. Bowman, again, he's saying that you were there 13 days. You actually entered the 3rd week. And
I can submit his timesheet that he signed on every day, where he put a signature next to the timeout that he was leaving. And yeah, it definitely doesn't show 4 o'clock every day. He did list out the actual time that he was leaving. 11:35, for instance, on his first day, 11:30 on his second day. Yeah, and he did put the reasons for that, but yeah.
so when you had said that, you know, you have to be there 160 hours, when you get to the end of 4 weeks, he's short on that. How do you make that up?
We add additional time for free. So they're freely allowed to come in after that, and until they are able to make up those hours, they're allowed to come in and get that training. We also, even after they have completed the course, if we complete the course and that we still don't feel that they're quite ready, or they don't feel that they're quite ready, they can get additional weeks of training for free, as long as they are putting in the effort to actually be there, to actually do the training. Lawrence was also known for, instead of doing work, he did a lot of chit chat. There was a lot of sitting and telling stories about his time in Alaska and this and that, and not a lot of doing the work, because so 70 hours or so of what is expected of them is observation. It's just watching the other students do things. And so there's going to be a lot of sitting around and watching people do things and not actually actively participating in the instruction.
So again, one more time, you say he was there for 13 days? 13 days he signed in?
Not all full days, but yes, 13 days.
How many hours? Could you add that up real quick?
Yeah, let me pull it up and take a look.
And can you fax that sign-in sheet to the same place that you fax this, or email to the email this contract?
Just 1 second. I will do that right now. It's a bit hard to get the exact amount, because there's you know, marked like 45 minutes here and 45 minutes there. So it might be a bit hard to get an exact number. And it is a regular occurrence that we have students that like to try and game the system by leaving at lunch, for instance. But our front desk is usually pretty good about catching that sort of thing and making sure they make up that time, because especially right now, CDL schools are being audited quite frequently.
Mr. Bowman, I'll give you the final word here.
Thank you, Your Honor. I can understand their circumstance in terms of being, having to evaluate each candidate coming in the door. I would have to say that there is an absolute learning curve to backing a commercial truck like that in a straight line. And it wasn't until fairly late in that game where I was given careful instruction on how to do that. And at the end of that, I was able to back the truck in a straight line reliably.
I didn't. Well, you know what the question I'm asking is, don't you? Why didn't you just finish out the course then?
Well, the circumstance, essentially, the instructors here in Olympia threw up their hands and say, "We're done with you."
Okay. Well, and you had the opportunity apparently to go down to Lewis County.
And I did. And it was obvious to me that the situation that they have in Chehalis is marginal at best. And I did not think the idea of having to drive 45 minutes there and 45 minutes back every day for 2 weeks to be a financially tenable situation.
If they had
Tell me again, when you were, on what date were you sent down to Lewis County? Was that, because looks like you started on September 15th, finished out the week from September 15th to 19th, finished out the week from September 22nd to September 26th. And then you started again on September 29th and did 3 days on there and then stopped. And what point in this were you referred to Lewis County? Was that right near the very end?
Well, it was the middle of that week, and
the last week.
Yeah, I was pulled aside by one of their seniors' instructions, who essentially said, we're done with you here. Go to Chehalis, which I felt rather offended by, actually.
And Mr. Fasano, that wasn't you, was it?
No, that would be our instructor that has 20 plus years of CDL instruction experience. So we've only booted students for safety reasons 4 times in the time that I've worked here in 3 years. It's not something we do regularly. We have an almost 80% passing rate on the first attempt at the test, which is exactly where the Department of Licensing wants us to be. We don't like giving up on students. It's not, something we tend to do. It's something our boss wants us to avoid at all costs. So it's not something we want to do.
All right.
Is all I'm saying. So
Mr. Bowman, and again, I have these timesheets as well as a contract that you decided that you had signed, and on you're asking for, apparently you paid 25. The amount of the course was, as far as I can tell, 2,500, excuse me. There was the tuition amount was $447.50, registration fee in the amount of $250 for a total of $5,000. You had paid, and then there was $160 for apparently UAs, as well as the physical. And then you paid the $2,500 and then canceled the check for the $2,660. The contract you signed says that, if you complete more than 50% of the course, then they're entitled to really the whole thing. And so, and they only got half. And so, and I, based on the timesheets, you did take advantage of more than 50% of the class time. And so I'm going to decide that you're not entitled to the refund of the $2,500 that you had paid. And it'll be a verdict for the defense here. Based on the amount of time based on the contract that you signed, combined with the time. If you'd have shown up there for 1 day and just said, no, this isn't for me, that'd be one thing. probably be getting all your money back. But when you show up for 2.5 weeks and the contract specifically lays out a schedule for when things can be refunded and how much they can be refunded, I'm going to find on behalf of the driving school. And then a judgment will not be entered. And if you want a copy of this, and the claim will be dismissed following trial. And if you want a copy of this, you can have it. Otherwise, you're free to go.
Okay, thank you, Your Honor.
You're welcome. Good luck to you both.
Thank you.
Are you here for court, sir?
I'm not.
Okay. Well, court's over, so you're free to stay, but.
And for the second time in 2 days, Def Leppard can hear. Court's over. You can stay. But you don't have much left here to go around here. Ladies and gentlemen, it's been a pleasure. It's been a pleasure presenting these cases from this week. And what a week it has been, even though it has been a holiday week, might I add. So many interesting cases. And, you got to chalk it up to they're trying to get things done before the new year. I expect this next week coming up will be as interesting as the previous week. So come on by, make sure you tune in about 8 p.m. Central Time, 9 p.m. Eastern Time every single night of the week. And I do plan on a New Year's Eve special. So if you're not going to watch the ball drop or you're not having parties with any of your friends, come on by and spend your New Year's Eve with Lone Wolf Usul and all of our friends here in chat, and we'll have about 4 hours worth of cases. As a matter of fact, it's about 4 hours worth of exactly 2 cases, if what I have in mind comes to pass. Ladies and gentlemen, it's been a pleasure presenting these cases for you today. I am your humble curator for this here channel. I am your host for this here weekend review, and we'll see you next time. Thank you very much for coming out. I'm your Lone Wolf Usul, and I am out of here. They have no clue what's going on. Thank you, ladies and gentlemen. Have a great day. Bow wow wow yippee yo yippee yay. Bow wow wow yippee yo yippee yay. Bow wow 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 wow. Bow wow 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 wow. Hey! Hey, check it out. Mama Wolfie gave me this amazing Christmas gift. This painting you see on the wall. That is an actual painting. I hope you can see it. It sits next to the geometric wolf. It is an actual painting that is titled Lone Wolf by some guy in Texas, and it's amazing. I hope you all can see it. I love it. Everybody have a wonderful weekend. I'm actually out. Bye. No. This is not a Ferris Bueller Day Off reference. You can't convince me that's go. It's over. We're done here. Bye. Just we're done. Okay? Don't start barking. Bye, guys. I'll see you later. Next time. The wolf will return.